Dear friends, I would like to share with you the latest judgment of the Honorable Supreme Court dated 17th July 2026, whereby the Honorable Supreme Court dismissed the SLP of the department against the order of the Allahabad High Court. In this case, Allahabad High Court quashed the order of the lower authority, which has imposed a tax on the dealer and rejected their ITC on the ground that the dealer of Agra has purchased the goods from Bombay dealer and the Bombay dealer has purchased the goods from other parties and other parties found bogus non-genuine. Therefore, the ITC claimed by the dealer of Agra on the purchases from the B dealer from the Bombay has been disallowed. It is highly unfortunate. We cannot penalize the honest tax person. The taxpayer dealer of Agra who purchased the goods from Bombay, he has the tax invoice, e-way bill, lorry receipt, and also he has made the payment through banking channel and has received the goods. What is his fault? Is his duty and he discharges duty to verify the particular of the Bombay dealer that he is registered with the GST department and his registration is active at the date of buying the goods from them. And it is showing on the portal of the GST department. And he has also filed his GSTR 1 and 3B also and shown all the particulars of the sale in his return. The purchasing dealer of Agra maximum can verify from the site which information are available by the government portal. He's verified that his registration is valid and he's shown the sale made to him in the return and he also discharges tax liability. What is the fault of the dealer of Agra? He should not be penalized because he has compiled all the conditions prescribed for taking the input tax credit prescribed under section 16(2)(c). Up now, this matter went to the Honorable Supreme Court. Allahabad High Court gave the relief to the buyer and quashed the proceeding of the lower authority, which they have initiated under section 74. 74 was also not attractive in this case. And when this quashing order was challenged by the department before the Honorable Supreme Court, he said nothing doing and SLP has been dismissed on 17 July 2026. Now question comes, this is a very important judgment which gives the benefit of the honest buyer and who has compiled all the conditions prescribed under section 16(2)(c). Because the activity of the selling dealers are not under the control of the buyer. Whatever responsibility and precaution buyer can take, he has taken it. And he has paid the tax also to the selling dealer. If selling dealer buy the goods from other parties, those other parties see, departments say are fake, not available, not existence, and they have not paid the tax. So how you can disallow the credit of the A on the basis of the C party? It was definitely it was a good order because when we claim the ITC, what we have to do? We should have a tax invoice and e-way bill, lorry receipt, payment through banking channel. GST should proper discharge of the liability and all particulars shown in the return to yourself. What accept you from the buyer? There are numerous judgment on this issue, but this was the latest judgment which I would like to share with you. And Honorable Supreme Court, in one of the most important judgments in the state of Karnataka, message Eco Gill Coffee Trading Private Limited. In this case also, the Supreme Court has held that buyer responsibility is to prove that he has received the supply of the goods, not beyond that. And and if the seller subsequently found non-existence, his RC has been cancelled with retrospective effect, which is also illegal. And he is not available at the address, and he disappear. He has not filed the return. He has not paid the tax. So it is not the fault of the buying dealer. Department has all the provision of the statute that they should recover the amount from the selling dealer. No action is taken against the selling dealer. Department straightway comes to the purchasing dealer because purchasing dealer is available before them. What is fault? He has discharged his liability and he has paid the tax also. And he has paid the tax to the person who is registered at that time, and registration was granted by the department. The tax was paid by the purchaser to the registered tax agent of the department. If tax agent subsequently disappear, does not pay the tax to the government, it is not fault to the buying dealer. Department cannot recover the amount from the buying dealer. This is a settled law. Thank you very much, my friends.